Picture this. You're several hours into a drive. Your legally owned firearm is in the center console where it always is when you travel. You know your home state's carry rules. You've been doing this for years without a second thought. Then about 40 miles after crossing into a new state, the blue lights appear behind you. Cracked tail light, the officer says, should be 5 minutes. But by the end of it, the officer is asking questions you can't confidently answer. Not because anything you brought is illegal at home, because you didn't think about what changed when you crossed that line. That kind of moment doesn't announce itself. It just shows up for careful people on ordinary days. Gun laws in the United States are not a single national standard. They are 50 different state systems built on top of federal law, shaped by decades of court decisions that most people have never followed. The gap between what you assume the law covers and what it actually does in a specific state at a specific moment is precisely where things go wrong. And when they go wrong, it tends to happen fast and quietly. If you carry legally and staying current on these laws matters to you, this channel is built around exactly that purpose. We translate gun law, court decisions, and carry realities into plain language before you need it, not while you're standing on a roadside trying to piece things together. Stay with this one. What you understand before something happens is worth far more than what you scramble to learn after something already has. Now, before we get into the details, it's worth saying clearly why this matters so much for ordinary people. The person this affects most is not someone who is careless or reckless. It's someone who took training seriously, got a permit, carries every day, and just hasn't kept up with rules that quietly shifted. That person can find themselves in a difficult situation through no real fault of their own, just a gap in what they knew. Knowing the law isn't a bonus for gun enthusiasts. It is a basic part of carrying responsibly. The most common mistake people make when thinking about gun rights in this country is treating the Second Amendment as a blanket guarantee without any edges. They've heard the language many times. The right to keep and bear arms shall not be infringed. They take that final phrase and build a simple picture in their heads. The right to own and carry a gun is essentially unlimited, and any law placing restrictions on firearms is automatically unconstitutional. That picture feels right. It also misses most of how American gun law actually works in practice. Courts have always recognized that constitutional rights have limits. Your right to speak freely doesn't protect you from fraud, perjury, or credible threats. Your religious freedom doesn't give you permission to break laws that apply to everyone equally. The Second Amendment follows that same pattern. The right it protects is real, individually held, and legally significant. Courts at the highest level have confirmed that, but it coexists with a long list of state laws, local ordinances, and federal regulations that courts are continuously asked to evaluate and referee. What makes all of this especially hard to track is that the landscape keeps shifting underneath you. A Supreme Court ruling reshapes the national picture. A state legislature passes a new law. A federal circuit court decision changes how rights are understood across several states. The gun owner who hasn't been paying close attention can find out the hard way that what was fully legal last year now has new conditions attached to it. That is not a hypothetical scenario. It is a real and regular occurrence that affects real people. Two court decisions in recent decades changed the national picture significantly, and understanding them matters. The first came down in 2008 and settled a debate that had been running for a long time. Does the Second Amendment protect an individual right to own a gun, or does it only apply to organized militias? The court answered clearly. It is an individual right. You don't need to belong to any military organization to own a firearm in your home for self-defense. That case, District of Columbia versus Heller, defined what the right actually covers at its core. Then in 2022, a second decision extended that right outside the home. A New York law had made it essentially impossible for ordinary citizens to get a permit to carry a firearm in public. The court struck that law down, ruling that the Second Amendment protects carrying in public for self-defense, not just inside your house. That case, New York State Rifle and Pistol Association v. Bruin, also changed the legal test courts must use when evaluating whether a gun law is constitutional. Dozens of state laws have since been challenged and revised because of it. What Bruin did practically was open a wave of legal challenges to carry restrictions across the country. Some of those challenges succeeded, others didn't. The result is a legal map that varies significantly from state to state, and that has changed meaningfully in the years since the decision came down. If you learned the rules before 2022 and haven't looked again since, there's a reasonable chance that some of what you know is outdated. The landscape after Bruin is genuinely different from the one before it. Here is where the gap between what people believe and what is actually true becomes most visible. Ask most permit holders whether they can take their gun across state lines, and most of them will say yes because they know about reciprocity. Reciprocity is when one state agrees to honor another state's carry permit, similar to the way states recognize each other's driver's licenses. The logic sounds clean. If my state approved my background check and my training, and your state honors that judgment, I'm covered when I drive through. That's the assumption most people operate on. The reality is considerably messier. Not every state has reciprocity agreements with every other state. Some states have modified or ended agreements over time without much public notice, and people operating on old information may not realize it. Some states have moved entirely to what's called constitutional carry, meaning no permit is required within their borders at all. That affects how reciprocity works in both directions. And underneath the permit question sits an entire layer of rules that most people never think to ask about. Specific storage requirements, location restrictions, and vehicle transport rules that differ significantly from state to state. Storage is the one that catches people most by surprise. Some states require a firearm being transported in a vehicle to be kept in a locked, hard-sided container. Some require the firearm and its ammunition to be stored in completely separate compartments. Some restrict whether a loaded firearm can be anywhere in the passenger area at all. What you do every day at home, legally, can be a criminal violation 50 miles into the next state. These are not minor technicalities that get overlooked. They are enforceable laws. They are the kinds of laws that result in real charges. Then there is the question of who is legally permitted to possess a firearm at all. Federal law permanently disqualifies certain categories of people from owning or carrying firearms. Felony convictions, certain domestic violence convictions and restraining orders, involuntary commitment to a psychiatric facility, some immigration statuses. The list is longer and less intuitive than most people expect, and some people genuinely don't realize they fall on it until a situation forces the issue. Every protection available to gun owners, permits, reciprocity, favorable court rulings, exists only for people who are legally allowed to possess a firearm in the first place. For a period of time, the question of what an officer can legally do when they discover a firearm in a vehicle was moving in a direction that should have troubled every lawful gun owner. Some lower courts were allowing officers to treat the presence of a gun as sufficient justification to search the vehicle. The reasoning was that firearms are inherently dangerous, that danger creates a safety concern, and that a safety concern gives an officer grounds to investigate. The problem with that chain of logic is where it eventually leads when you follow it all the way through. The right to be free from unreasonable searches is protected by the Fourth Amendment. The right to keep and bear arms is protected by the Second. When courts were using one against the other, treating legal gun ownership as a reason to strip away privacy protections, they were forcing people into an impossible position. Carry legally or keep your privacy from government intrusion. Pick one. The Constitution doesn't ask anyone to make that trade-off. Both rights exist. Neither one was designed to cancel or diminish the other. The Supreme Court addressed this directly. The court ruled that the mere presence of a lawfully owned firearm in a vehicle does not, by itself, constitute probable cause for a search. Probable cause means a specific, genuine reason to believe a crime has been committed. Legal gun ownership is not that. The ruling came from justices across the full range of political perspectives on that court. When people who rarely agree on anything related to firearms or law enforcement land unanimously on the same answer, that signals the principle at stake is not a close call. It is clear and foundational. Understanding what that ruling accomplishes requires understanding what it does not cover. It protects lawful possession. If an officer has legitimate reason to believe someone is prohibited from carrying, the ruling doesn't apply. If a firearm is stored in clear violation of state law, the officer now has a specific, articulable basis to act that goes beyond the gun simply being present. And if other circumstances at the scene combine, contradictory statements, suspicious behavior, other observable indicators, those factors can build probable cause independently of whether the firearm is there. The ruling closed one door for law enforcement. It didn't close all of them. This is worth saying directly. Most people who carry a firearm are not looking for ways around the law. They're trying to stay within it. The challenge is that the rules are genuinely complicated enough to trip up even careful, well-intentioned people, not because they're careless, but because the system moves and doesn't always announce itself when it does. A state law changes. A court decision shifts how something gets enforced. Something you relied on confidently last year has a new qualification today. Staying informed is not extra effort. It is the basic maintenance that keeps lawful carry lawful over time. The people who carry responsibly for years and never find themselves in legal trouble are not people who just got lucky. They're people who built a habit around knowing what the law requires. They check the rules when something changes. They research before they travel. They don't assume that what worked last time will automatically work this time. That habit doesn't require a law degree. It requires treating the legal side of carrying the same way you treat the safety side, seriously, regularly, and before something goes wrong. The people who engage most actively in this community are the ones who carry regularly and actually think about how the law applies where they live, the questions they raise, the state-specific details they bring in from experience, the situations they describe from real encounters. Those things make these conversations more useful than they'd be otherwise. If you haven't joined that community yet and this kind of discussion is what you're looking for, this is a natural moment to do it. People who take this seriously tend to find each other here. Now let's get into the practical side, because legal principles are only useful if you know how to apply them when something real is happening. The first thing to understand about any traffic stop is that the first 30 seconds determine the tone of everything that follows. When the lights appear, pull over promptly and safely. Don't hesitate or drag it out. Turn off the engine. Keep both hands on the steering wheel where the officer can clearly see them. Roll down your window. If it's dark, turn on the interior light. These actions remove uncertainty for the approaching officer, and that matters more than most people recognize. When the officer reaches your window, don't reach for anything before you speak. If your firearm is anywhere near where you store your registration or insurance, an unannounced movement toward that area can turn a calm stop tense very quickly. Speak first. Tell the officer where your documents are and let them direct what happens next. Something direct and calm. My registration is in the glove box. I want you to know I'm carrying legally. How would you like me to proceed? That combination of honesty and deference does considerable work. It shows cooperation, removes surprise, and keeps the officer in control of the next step. Know your state's duty to inform law before any of this ever becomes relevant to you. Some states require you to tell an officer you're carrying the moment a stop begins, not when asked, immediately, at the start of the interaction. If that's your state, do it every time without exception. Other states have no such requirement, and if the firearm isn't visible, you're under no obligation to volunteer the information unless directly asked. But if you are asked, the answer is always honest. Lying to an officer about whether you're carrying creates its own serious legal problem, completely separate from whatever else is happening at that stop. At some point in a stop where a firearm is present, an officer may ask to look through your vehicle. It usually comes out sounding reasonable, something about safety, something about a quick look to clear things up. Your instinct as a law-abiding person who has nothing to hide is to agree, but the moment you do, you've given the officer permission that no ruling can take back. Consent to a search, once given, overrides constitutional protections. You cannot undo it later in a courtroom. What you agreed to in that moment is what stands, regardless of what you thought you were consenting to. You have the right to decline. Do it calmly, without hostility, without making it confrontational. Something simple. I respect what you're doing, but I don't consent to any searches. That's all it requires. No lengthy justification, no quoting case names. Exercising the right to decline is not legally suspicious behavior, even if the officer works to make it feel that way. The pressure tactic of asking why you'd refuse if you have nothing to hide is designed to make refusal feel like guilt. It isn't guilt. It's a constitutional right. Recognize the tactic and don't be moved by it. After a refusal, resist the urge to fill quiet moments by talking. Many people explain their route, what's in the car, where they're going, believing it will make things easier. It frequently does the opposite. Voluntary explanation can hand the officer information that becomes the building blocks of probable cause. You can politely decline to answer questions beyond license and registration. Saying you prefer not to answer further questions is a protected exercise of your Fifth Amendment rights. It is not obstruction. It is not evidence of wrongdoing. People who try to talk their way out of a search often end up inadvertently talking themselves into one. If an officer proceeds to search after you've clearly refused consent, don't interfere physically, but state it clearly, loudly enough that a body camera will capture it. I am not resisting, but I do not consent to this search. Then let it proceed. A search conducted after a clearly stated refusal becomes the foundation for a legal challenge. Evidence found in an unlawful search can be challenged in court and potentially thrown out. Your composure in that moment is not weakness or resignation. It is the beginning of your legal case. The courtroom is where this gets resolved in your favor, not the roadside. Once the stop ends, write everything down before you've driven 5 miles from that spot. The time and location, the officer's name and badge number, exactly what was said and by whom, what you agreed to and what you explicitly refused. What justification, if any, was offered for a search or extended detention. Memory under stress is far less reliable than people expect, and it fades quickly. The details you capture in the first 10 minutes after a stop are what attorneys actually work with, Give yourself and anyone who might represent you something specific and accurate to build on. On the question of traveling across state lines, a federal law called the Firearm Owners Protection Act provides some coverage for gun owners passing through states with stricter laws. If you're traveling from a state where your firearm is legal to another state where it's legal, and a more restrictive state sits in between, the law says you're protected as long as the firearm is unloaded and stored in a locked container away from the passenger compartment. That protection is real. It is not unlimited. Some states with strict gun laws have prosecuted people who relied on it, and courts haven't always applied it the same way. The safest practice for traveling with a firearm is to research the specific laws of every state you'll drive through before you leave, not when you're already on the road. That means storage requirements, permit recognition, location restrictions, and any state-specific transport rules. A few minutes of preparation before a trip is the kind of low-effort investment that prevents a high-consequence problem. The federal travel protection exists as a backup. It shouldn't be the only thing you're counting on. Carry restrictions in public spaces are the other place where careful people get caught unexpectedly. Most permit holders know the standard off-limits locations: courthouses, police stations, schools and surrounding zones, government buildings with security screening. But the full list in most states goes significantly further: places that serve alcohol, medical facilities and hospitals, certain public parks, houses of worship in some states, and private businesses have their own legal authority. When a business posts the legally required notice that firearms are prohibited on its premises, entering while carrying can be a criminal violation in many states, regardless of whether you saw the sign and regardless of whether your permit is valid. A carry permit opens most doors. It does not open every door. Let's bring this together in a way that's actually useful to hold on to. The Second Amendment protects a real and significant right. Courts have affirmed it at the highest level. The right to own and carry a firearm for lawful purposes is not in serious legal doubt. What is complicated is how that right lives alongside 50 different state systems, federal law, and court decisions that keep redefining the edges. That complexity isn't going away. What you can do is stay ahead of it, consistently, as a regular part of how you approach the responsibility of carrying. There's a version of this topic that gets flattened into simple slogans and online arguments: shall not be infringed, no compromises, all or nothing. That version isn't very useful to someone standing at a traffic stop window trying to figure out what to say next. The version that actually protects you is grounded in how the law works in real situations, where it stands up for you, where it doesn't, and what habits and knowledge keep you on the right side of it when it matters. That's the version worth building. If you want to keep getting this kind of breakdown, the kind that converts legal complexity into something you can actually use, this is where to stay. Gun law keeps moving. Court decisions keep landing. State laws keep getting amended. The people who stay ahead of those changes treat staying informed as part of what it means to carry responsibly. Understanding what the law requires before something happens is always more useful than trying to sort it out after. That's what this channel is built around. Come back for it. So here's what to carry forward from this. Know your home state's rules completely. Research every state you'll travel through before the trip begins. Store correctly wherever you are, not just at home. Handle police encounters with calm, visible hands and honest, clear communication. Know your duty to inform obligation and follow it. Decline searches politely if that's your choice, and understand that doing so is your right. If something proceeds further than it should, document everything immediately, and let an attorney fight that battle in a courtroom where the law can actually do its work. Rights don't protect themselves automatically. The people who understand how to exercise them correctly are the ones those rights actually protect. Stay calm, stay lawful, and stay ready.